Hi, I'm Rosemary Marin. I'm an attorney at the Scott Hulse Law Firm. We have offices here in El Paso, in Las Cruces, and in San Antonio. I'm a labor and employment lawyer, and I represent employers. So I have been advising clients on the Family First Coronavirus Response Act. I'm going to call it the FFCRA, that just was passed last week. It's a very new law. I'm certainly not an expert in it, and today is not for the purpose of providing any type of legal advice. I'm really here just to provide general guidance and to help folks better understand what their responsibilities are as employers to your employees and what you need to do for purposes of protecting your business. I want to say that I'm not sick. You may hear me sniffle or cough. It's just allergies. I'm feeling perfectly fine. I'm not sick, but you may hear that, so I thought I'd put that out there. We are practicing social distancing, by the way, and so it's all good. So generally speaking, I want to address in a non-coronavirus era, apply in the workplace now. We've, I think, all seen probably some doctors and nurses that don't have protective equipment at their workplace and all of that. What I will tell you is that there is a great website with the World Health Organization. If you just put in who.gov, it gives you a very good overview, and you look up coronavirus and it'll give you that, and then you break it down into healthcare professions. It'll break it down. So the big point there is to assess the hazards in the workplace, minimize them as much as possible, evaluate the risk of exposure to your employees and to others, implement some safeguards for your employees and for others, and then some of those might be, for example, administrative controls like stay home. There are a lot of businesses in El Paso and Las Cruces who are staying home in accordance with the mayor's order, except for essential businesses. You want to practice safe work practices, and then you want to provide the protective equipment to your employees in accordance with the law. Whether those are available or not is a different story. That's not what I'm here about. I'm just going to tell you what the law is. So that's the answer to that question. I would, if you've been running a healthcare organization that has healthcare workers already, then you know what those rules are, and those are the same rules that are applicable now. With regard to the coronavirus, of course, the guidance is frequent cleaning of hands with alcohol-based rub or soap and water, covering your nose and mouth with a flexed elbow or disposable tissue when coughing or sneezing, and avoiding close contact of 6 feet or less with somebody who has a fever or a cough. And so really that's what the guidance is for everyone. Healthcare workers who are on the front lines, they've got so much exposure to so many different things, not only the pathogen exposure but the working hours, the psychological issues, the fatigue, occupational burnout, the stigma of that, the physical, or have younger employees take the work assuming that they're essential. Excuse me. So the answer to that question is really tricky. Under the Age Discrimination and Employment Act, anybody over 40 is protected from any age-based discrimination on any employment decision that is made in the workplace, including assignment of work. So your question goes directly to that question. It's an excellent question. If the employee is in any of the risk categories, so it's not just that they're older, but that perhaps they have an underlying condition that may greater expose them of some kind of lung condition, diabetes, if they're receiving treatment for cancer, those kinds of things. If they fall in any of the categories, I think everything that I've read and that I've discussed with colleagues is it is discriminatory to decide that you're going to send all of the people in the 65 or older category, which is the high-risk folks, that you're going to just send them home. If they don't want to go home and they're essential employees, as you said, then it could be discriminatory that they want to continue to work, but because of their age, you're sending them home. At the same time, you're thinking, well, I just want to protect them. I want to make sure that they're okay. I get that too. And so I think the best practice, based on the colleagues that I've spoken to and all of the reading that I've done in the last few weeks, is put a list of the risk categories in writing, and ask all of your employees, not just your older employees, if they fall into any of those high risk categories. If they do fall into any of those high risk categories, then you can ask them, do you want to go home? It may be that they want to go home, but they're not able to because they're essential, you need them in the workplace. That's a more difficult answer, and that's really a case-by-case situation that you should best discuss with your lawyer. What I will tell you generally about that is that if an employee is in a high-risk category and they want to go home and you can find a way, and your business is able to sustain them not being there, I think that's the preference. If you have to have them there, then the next best is try to isolate them, tell them why you're doing it, obviously, in a place that would be less risky, so that they're always away from people more than 6 feet away, that they're always in a protected place. If you have protective equipment that you could provide, like a mask and gloves, hand sanitizer, those kinds of things, even better. But it's not a black and white situation. It's not an easy answer. I will tell you that any kind of isolation of a worker in other circumstances, because of their age or because of their disability even, would be a problem under this virus, because of the guidance from the Centers for Disease Control, the CDC. Everybody's doing their best to ensure that they follow the guidance, and that's all that you can do. If you've got any questions about that, you should reach out to a labor and employment lawyer who can walk you through the particular facts of the situation and help you with that. Another question: now that most companies are working remotely, will they have to provide the materials needed? If employees have to use their own devices, will employers provide compensation? Are employers liable for any damage or added costs for using their personal devices? Another fantastic question. So maybe is the answer. Again, it's an individualized analysis, but I will tell you this. The best practice is to put everything in writing if your employees are going home remotely, to work remotely. If they're going to use your equipment, if they're going to use their own equipment, or a combination of both, that should be in a policy that you can give them. And you can do it now, even if they're already home and you haven't done it before. Get with your lawyer, and if you don't have one, look for a good labor and employment lawyer who can put a policy together for you for telework. The telework is somebody who's just working remotely from their house. And you can set forth all of those requirements in your policy. You're free to do whatever you need to do to ensure that everybody understands the relationship there. You're not required to provide equipment, but if an employee doesn't have equipment to work with and you're not providing the equipment, I don't believe that it's a fair thing to do to require them to buy it and the employer make them use it without any consequence. So that doesn't seem like a fair thing to me. It seems that if you're going to take advantage of the opportunity to have them work from home, then the employer bears some responsibility to ensure that they have equipment, even of their own or of the employers, that works properly. If maintenance and other things like paper for a printer, for example, are required for doing the work, then I would say that that's probably a fair thing to do as well. But you don't want people to abuse it, right? So you want to be sure that you make that up very clear up front, that their equipment is to be used only for work. Everybody has to be on the honor system at this point. And so hopefully they'll just use it for work, and you'll have good policies in place that'll put all of that in order for you. It's really up to you on how you do that. What are precautions employers can take in terms of payroll? Are there certain guidelines that they must follow before they make decisions to lay off employees? Again, an excellent question. It's a very loaded question. It has a lot in it. I will tell you again, the layoff issues are very much individualized to the employer and as far as the employee as well. What I would tell you generally about layoffs is, number one, you want to be fair, and you want to stay as objective as possible. a really objective criteria is seniority, but that's not always the best interest of the company to have the person that's been with you the longest to be the person that is selected to stay versus somebody who's maybe has a better skill set. It's a difficult analysis. You should go through the whole company and look at jobs, and your comparator employees are the people that are in those same categories. So let's say that you have a law firm and that you have lawyers and you have paralegals and you have secretaries and you have these people, you have your IT people, you have administration. So the folks in each of those categories, for example, you would compare them to each other and then use the same criteria for those employees in those categories the same criteria for all of them. So if you're comparing apples to apples, so look at all the senior lawyers, and by that I mean your shareholders, your owners, and then you would look at your associate attorneys, and look at all of your shareholders and compare them to each other using the same criteria, and then do the same thing for all of the other job categories. And as long as you're doing that fairly and you're not using somebody's age or race or national origin, religion, disability, any of those protected classes, if you're not using those protected classes to make those decisions, then you're probably going to be okay. I would say generally I would talk to a lawyer before you do any layoffs, because that's a very dangerous area of the law. And number two, I would say document everything, all of your decision making, and direct that to your lawyer so that it's attorney-client privileged. And then you have that to remind you of your reasoning. If somebody brings a claim against you at some point in the future, you have that documentation to explain why it is that you chose one employee over another laid off. So a very, very difficult situation. Hopefully we'll have less layoffs now. If the stimulus package passes today, we'll have less people laid off and it won't be as much of an issue. But certainly it's been a very, very big issue for the last 2 or 3 weeks in my practice. Another question, can commercial property owners evict a tenant if they don't pay rent? Does the no eviction policy apply only to a residential situation? If business owners are locked out of their business due to rent issues, what would be the action? Those are all really good questions. I think I know the answer, but I'm not going to answer them because I'm not a real estate lawyer and it would not be appropriate for me to do so. If you've got those questions, you should reach out to your broker or your real estate lawyer who can answer those questions better for you. I'm here to answer any other questions that might come up with regard to the coronavirus and its effect in the workplace. Okay, so one of the question is how do we deal with part-time employees and how do we pay them? So under the I'm going to call it the FFCRA, part-time employees are the calculation for the wages of those part-time employees is during the paid sick leave you would, and it's actually a calculation the same on both the emergency paid sick leave and the FFCRA. Excuse me. In both instances, you would take their wages and average. So if they have their schedule, you would look at what their schedule is and you would prorate their wages based on that schedule versus a full-time pay. If you don't know their if you don't know their hours or it varies from time to time, then you would take an average over the last 6 months that they've worked with you and determine what their average weekly wage is at that point, and that's how much you would pay them under the FFCRA and also under the Emergency Paid Sick Leave Act. If they're with you less than 6 months and they're part-time employees, then you would average their weekly based on the amount of time that they've been with you. You would pay those wages that way. Waiting on a couple of questions here. If employees are seeking unemployment, so there is a much easier process for receiving unemployment under this law as well. It's supposed to be a much more user-friendly sort of process so that people don't have to use the same qualifying, the qualifying criteria for receiving unemployment benefits are, they're relaxed under this new law. Employers can also submit, and I don't remember the name of it, I think it's all called a class. Let's say that you're going to lay off all of your employees. You can get on the Texas Workforce website, on the New Mexico website as well, and you can submit a class submission for all of your employees. The benefit of doing that instead of having them do it is they're trying to get people to less bog down the system. So it helps the employer and the employee. The employer fills in all of the basic information for the employee, and then the employee doesn't have to do that. The commission will then go in and look at that list, and when the employee submits everything, the employee doesn't have to submit, the employer submits it, and then unemployment benefits start without the employee having to actually have an individualized application for that. So it is helpful. Okay, I'm a small business owner. I feel that the small businesses should have a 0% interest loan. Is there any organization doing this? I don't know the answer to that question. I will tell you that under the stimulus package, if it passes as written in the Senate, and that's all I can tell you, I'm certainly not an expert in that law either, since it's not even a law yet. But the Senate bill does have a low interest. I think it's 3 or 4%. I believe it's 4% for businesses, and it's a forgivable loan that will be completely connected to the percentage of employees that you retain. So let's say that you have 10 employees and you retain them all, you don't lay them off. You apply for that loan and it's at a low interest rate. If you keep 100% of those 10 employees, I believe that the law, and again, it's a caveat, it just came out and it's not law yet, it's just a bill. If it stays as is, then that percentage of 100% will be forgiven on the loan. So that will be it'll be better than 0%. It'll be, you don't have to pay it back. If you kept 9 of them, that's 90%, you would have to pay 10% back. If you kept 8 of them, that's 80%, you would have to pay 20% back. If that makes sense, I hope. So it's a very, very good provision in the Senate bill that if it makes it through the House in that condition, it should be a very good thing for employers going forward. If employees took a leave in the last quarter, will that affect the amount of unemployment pay? So the unemployment benefits are calculated based on the average time that they've worked with you and then taken into an average calculation of wages. You have to follow the unemployment folks. I am not certainly an expert on unemployment insurance, and I haven't been directly involved in advising employers how to do that with the Texas Workforce Commission or in New Mexico. So I want to be really careful to just tell you, follow the instructions. They'll tell you how to calculate those wages. I do believe that leave is going to count because they're going to take a certain number of weeks and take an average weekly pay there. What about employees being required to work remotely who might not have a laptop or Wi-Fi? Are employers required to provide all equipment? So I've answered that question. I don't know if people can rewind it. I don't want to make people have a repeat answer to that, but it is in the earlier part of the presentation. Some stories about some workers pushing for hazard pay. How does that work? I don't know. In this situation, it seems like everybody's in a hazardous situation to some degree. There isn't anything in the FFCRA that has a special provision for hazard pay. And so that's all I can really tell you about that. All right, so, a couple of other things that I thought, if we get questions, I'll certainly answer them. Just sort of some general ideas about this. The paid family medical leave is everybody over with 500 employees or less. If you have 50 employees or less, there is an exemption, but it's not an automatic exemption. I think that's a very big misconception, that people think if I have less than 50 employees, I don't have to worry about it. You do have to worry about it. The exemption is if you have 50 employees or less and payment of wages under either the Emergency Sick Leave Act or the FFCRA would jeopardize the viability of your business. So far, there's no regulations on it. There's no guidance on what that means, definition of what jeopardizing the viability of the business is. The best advice that I've seen is from the Department of Labor, which is the organization that's going to be enforcing this law anyway. And what they're saying is document your reasons why you think that this is jeopardizing the viability of your business. Really what it means is wait and see. We don't know what that means yet. At some point somebody's going to figure that out and give you some guidance. At this point it doesn't. So I'm telling my employers, look, in other areas of administrative law, when governmental agencies are looking at your business for compliance and they're looking at undue hardship, for example, under the Americans with Disabilities Act, they would be looking at what would it be to pay this employee or to do this for this employee, whatever it is for this employee, versus what it is costing the business as a whole. My guess, and I don't know because nobody knows, but my guess is that they would be looking at the entire business versus how much you're having to pay to comply with this law. So if you're having to pay one person, that might be very different from having to pay 49 people under this law. And so just understand that there's not any guidance other than to document your reasons and hope for the best, really, with regard to the viability of the business. They also tell you for sure, don't send your reasons to the Department of Labor. It's all just going to be for now internal documentation that you would submit if it were that somebody were to complain that you were not complying with this law and the Department of Labor sent somebody out there to do an audit on your workplace with regard to that. Then you would need to understand that you've got to have that documentation to show that it does affect the viability, jeopardize the viability of your business. I would say that documentation is not just your reasons, but also your financial situation and how that compares if you pay them versus if you don't pay them. I thought I'd put that out there if we don't have any more time for anything else, because it is a very important topic that a lot of employers in El Paso and Las Cruces have less than 50 employees. And I've heard quite a few employers tell me, oh, well, I'm exempt. I don't have to worry about it. I've got less than 50. Just understand it's not automatic. You will have a burden of proof on that, and you need to be sure that you have your documentation together. All right, so another couple of things. The reasons for the leave under the emergency paid sick leave, there are 6 of them. The employee is subject to an isolation order by a federal, state, or local authority with a quarantine that we're under that in El Paso and Las Cruces at all of those levels. The employee is advised by a healthcare provider to self-quarantine due to COVID-19 concerns. So, for example, they traveled out of the area to an infected area, which is pretty much anywhere in the world now, or they've been exposed to the illness, or they're with somebody who's been exposed to the illness who's in their household. There's those criteria. I didn't memorize them, but those are generally it. Or the employee has experienced COVID-19 symptoms and seeking medical diagnosis. Or the employee is caring for an individual, not just a family member, it could be anybody, who's subject to a federal, state, or local quarantine and advised to stay home. Or the employee is caring for the employee's child if the child's school or place of care is closed, or the child's care provider is unavailable due to the COVID-19, or the employee is experiencing any other substantially similar condition. So that's your catch-all that nobody knows what that means at this point. If you fall under any of those 6 categories as an employee, or your employees do, then you need to understand that though that's the emergency paid sick leave, that would be the first 10 days, a total of 80 hours, a max of 80 hours of pay for those categories. And the rate of pay for that depends on the reason for the leave. Generally speaking, it's going to be their pay up to a max of, I believe it's $511 per day, and $10 total per employee for their own use, and $200 per day or $2,000 total for their care of others. So generally speaking, that's the paid sick leave, emergency sick leave. Under the FFCRA, the Department of Labor's question is, when am I able to telework under the FFCRA? Sorry, that's the wrong question. I had marked some questions that the Department of Labor, I thought, answered and did a good job with in answering. When calculating wages, yes, they're including everything that the employee would have worked, and so you look at the average of the 2-week period before the emergency sick leave, and then you would calculate that up to the maximum amount that anybody is. So the question to the DOL was, is all leave under the FMLA now paid leave? The answer is no. The only type of family and medical leave that is paid leave is expanded family medical leave under the Emergency Family Medical Leave Expansion Act. When such leave exceeds 10 days, this includes only leave taken because the employee must care for a child whose school or place of care is closed or child care provider is unavailable due to COVID-19 related reasons. And a really good question, are the paid sick leave and expanded family medical leave requirements retroactive? The answer to that is, according to the DOL, no. It's from the date that they begin taking the leave and forward to that. All right, well, thank you all for being here. If there's not anything else, we will have this video posted on the chamber page for everyone to reference, so that if you came in a little bit late, you can access the video, and if you had questions that perhaps were not answered in the time that you watched it, you can go back and look at it. Thank you for joining us.